Hi, in this video we're going to talk about the second option in terms of estate planning and how much that may cost. Again, we're talking about exploring the different pricing options and strategies to do the estate planning. So anyway, I told you before that doing nothing is a form of estate planning, and doing nothing, yes, it doesn't cost anything at the beginning, but may cost a lot of money at the end. So when you say, no, I don't like that option, what else do I have? Then the attorney may say something like, okay, you may do what is called a will-based plan. And what is a will-based plan? A will-based plan is a set of documents where you have a last will and testament, a durable power of attorney, healthcare surrogate, and living will. So basically, again, the question is, when we do estate planning, what we're trying to address is what's going to happen to me and my money if I either become mentally incapacitated or I die. So let's go one by one. If I do a will-based plan and I have a durable power of attorney, I have a healthcare surrogate, and I have a living will, and I'm diagnosed with either Alzheimer's or dementia, so in other words, I become mentally incapacitated, or I am in a coma after a huge car accident and I'm there without being able to express myself. So what's going to happen? Well, remember, when in the nothing option, you end up in guardianship because you never stated your preferences in writing. So now, under this option, you are expressing your preference in these documents: a durable power of attorney, a healthcare surrogate, and a living will. So because you have these three documents, it may not be necessary to go through guardianship. So basically what's going to happen is, you told the court, you told everyone, hey, look, if I become incapacitated, I trust my spouse, or I trust this kid, not the other one. But if this kid is unavailable or unwilling to serve, then I want this other kid to do it for me. And this is the things that I want him to do. So you specify each power or authority that you want to grant to that particular person. And you go through that with the attorney, and the attorney will ask you, hey, look, what if you want to make gift? Do you authorize your agent to make gift? Yes, okay, so we put that in writing, and so on and so forth. The same thing with this designation of healthcare surrogate. Here, what we're saying is, who's going to make medical decision for you in case you are unable to do so? So you are in the hospital and you are under the effects of anesthesia, so who's going to talk to the doctor about you and your care and your treatment and your therapist and so on and so forth? So that person designated in this document is that person that will talk to the doctor. So again, very important, you already have that person nominated there. Here, in the living will, you're saying, look, if I am in a terminal condition, there's no chances of surviving, so I authorize my surrogate to disconnect me, unplug the cord. So basically that's what the living will is. So now everyone knows that if you are in an end stage condition or terminal condition, everyone knows that you authorize a trusted person to unplug you and let you die in peace. So basically that's what the living will is. So now we know. So with this, we don't have to go through guardianship. And remember how much guardianship was? It was about $20,000 in legal fees and court costs. So now we may avoid that with this plan. So again, durable power of attorney, healthcare surrogate, and living will. Now, second question, if you die, what's going to happen to your stuff if you die and you do a will? Okay, you still go to probate. Again, get this clear, a will goes to probate, because the probate is the process under which the judge says this will is okay, so we're going to use this will to distribute the assets of the decedent. So the will says, I'm blessing this will. So to do that, you need to go to court. You need to go to probate. So that's what probate is. But here is way more different than the nothing option, because here you are naming who your representatives are or your executor, who's going to be in charge. Here you can also say, okay, I want to split my assets in different ways. I want to give, everything to my spouse, but these are going to my kids. These bank accounts can go to the other kid, and so on and so forth. You can decide your rules. You can say, no, thank you, I don't like you to this one, and say, okay, these are my rules. So long as you respect some basic provisions that are in the Florida statutes, you can dictate your own laws about the will. You can, for example, say, I want to give some money to my favorite charities. I want to, provide for my cousin or for my nephew or for my grandchildren or anyone who you want. You can split that. So in the nothing option, you didn't have that option because nobody knew. But here you put it in writing. Yes, you still go to probate. We still have that 5 to 7%. But at least you have your own rules about distribution. So here, pricing, you will hear pricing, many different pricings here, and here's the key. Again, the key is not about the form. So you will see in the internet that wills for $100 or for $50, or you download from LegalZoom. I don't know how much they cost, but or you can even download forms from the internet that are free. So be careful about that, because again, there's no discussion between you and the computer about your wishes and things like that. So that's why they are so cheap, because all they do is they put your names and the names of your kids and the names of your family and things like that, date of birth and all that kind of stuff. But it doesn't say who's gonna get what and what percentage and anything like that. So those wills are very cheap. They can go for $50 or $100. So now when you talk to an attorney, the cost may go up, and that's when you need to decide whether that is worth it for your family, because at that point you will say, okay, I want to do it right. I want to make sure that my money goes to these people, and I want to make sure that my trusted advisors are these people, and so on and so forth. So expect to spend anywhere from $750 to $2,000, I mean, depending on what you would try to do. Sometimes you may want to establish trust within your will, and that is the subject for another video, but that's when the price may go up. So before thinking about pricing, again, talk to an attorney, take advantage of the free consultation, and make a good decision about this. In the next video, we're going to talk about trust, the third option in your arsenal.